held that the rivers, forest, mineral and other natural resources are important constitutes of natural wealth, and these are not to be frittered away or exhausted by one generation. And the Supreme Court had shown its willingness to protect the rights of those who have yet to born in number of cases, like Justice Jagananda Rao in Andhra Pradesh Pollution Control Board versus Professor M.V. Naidu. He adopted a far visionary approach and held that in today's emerging jurisprudence, environmental rights are described as third generation rights. Environmental rights are described as third generation rights, and the court attempted to make the people aware about their pious duty by referring the way in which a society cares or does not care for its dirt, its land. It reflects that degree to which the society cares about the future generations. So, regarding sustainable development, the dilemma between sustainable development and environmental protection has been removed with the adoption of this theory in a number of cases. Like Calcutta High Court in People United for Better Living in Calcutta versus State of West Bengal, it observed there should be a proper balance between the protection of environment and the developmental process. And the society shall have to prosper, but not at the cost of the environment. And in the similar vein, the environment shall have to protected, but not at the cost of development. So there shall have to be both development and proper environment. And as such, a balance has to be established and administrative actions ought to proceed in accordance therewith. And thereafter, in Narmada Bachao Andolan's case, the Supreme Court held a balance is required to be maintained in the development and protection of environment, and every aspect of development should be based upon sustainability. So, and I'm going to conclude in SR Oil versus Halar Utkarsh Samiti, Honorable Mrs. Justice Rumapal and Justice Dr. A.R. Lakshmanan held that this is the sole aim of law, sole aim to balance economic and social needs on the one hand with environmental considerations on the other. But in a sense, all development is an environmental threat. So the court made it clear that objective of all laws on environment should be to create harmony. Harmony between the issue of development and issue of environment protection. And applying the theory of social engineering, former Chief Justice R.C. Lahoti, he made it clear that private interest stands subordinated to the public good. So on the basis of the analysis made of these judgments of the Supreme Court, it can be submitted that the judiciary in India, in its color and content, revealing new horizons, has enriched Article 21 of the Constitution guaranteeing protection of life and liberty. The courts in India have recognized that every man's home to be his castle, which cannot be invaded by toxic fumes or tormenting sounds. The underlying approach of the courts is to prevent the ruthless exploitation of environment and provide the relief to the aggrieved persons in the event of their suffering. In sum up, the interest shown by the Apex Court in evolving the principles of law and environmental protection is equally encouraging, and the rules and principles settled at international platform like intergenerational equity, sustainable development, precautionary principle, and doctrine of public trust were made the part of our domestic law, domestic Indian legal system. So these reflect the alive and active approach of Indian judiciary. And not only sticking to the affirmation of the above referred principles, the Supreme Court in Andhra Pradesh Pollution Control Board versus M.V. Naidu, second, it pointed out that the deficiency in judicial and technical inputs in the appellate authorities functioning under certain environmental laws, and it also recommended that there are some areas where we must improve. All the organs of the government must improve, and the people's participation, which is the main problem in India, that must also be assured. And in pursuance of this directive issued by the Supreme Court further issued guidelines to the UGC, to the CBSE to introduce environmental studies as a subject. And here, one more thing I would like to point out, the observation of learned Justice Y.K. Sabharwal, the former Chief Justice of India. His Lordship expressed his concern towards the implementation process. As I earlier stated, that in India, the problem is not absence of law. Problem is the absence of implementation of law. And this view finds its supports from the observation of Justice Sabharwal. His Lordship stated, what happens? What happens when violators or abettors of the violations of environmental law are those who have been entrusted by law with the duty to protect these rights? You can have the case of one leading lawyer is there, Mr. M.C. Mehta versus, I don't want to quote the name, in Himachal. So the task becomes more difficult. It becomes more difficult and it requires urgent intervention by the court so that the rule of law is preserved. Rule of law does not mean that the paper promises those were made and those have become just the asset of the constitution. Rule of law in real sense, the dignified atmosphere. So his lordship observed that the rule of law is to be preserved and people should not lose their faith in it, and the person who wherever the violations are found, those are to be punished. So the upshot of aforesaid analysis is that in order to combat with this problem, integrity and commitment of the executive should be ensured, as corruption in India at all levels has been continuously going on having hand in hand with inaction as regards to the societal aspects. Lack of implementation of legislative instrument is continued till the court intervenes at the behest of some public spirited persons through PIL. So therefore it is proposed to constitute an accountability bench in the Supreme Court as well as in the High Courts for exclusive adjudication of cases involving inaction. As we have seen in right to information sphere, inaction, inactivity leads to punishment. So similarly, the responsibility, the accountability bench is to be established at the state level, at the union level, and inaction should be handled over there. So inaction on the part of executive and for the purpose of fixing their responsibility. So this may be justified on the ground that the person aiding to pollution for playing with the life of the people at large should be held guilty, and there should be no exception to this rule, and in this way we must assure the rule of law.
Thank you. Thank you, Mr. Tarun Arora. Guilty should be punished. Of course, if he pollutes, he should be punished immediately. However, I may not agree on the point that only the PILs are making the change. And only the PILs, or through the PILs, we are getting the environmental protection rights.
To some extent.
Of course, to some extent. But anyhow, we, in this session, friends, we were supposed to have 2 more speakers. But you may see the shortage of speakers as well as the listeners. I would like to invite question and answer. If somebody asks some question on this subject.
I've got a small disagreement with your last statement, which I've done in the conclusion. Like you were telling that anybody who pollutes should be punished. I believe that development goes hand in hand with pollution. So it's not about, we have the laws not to curtail pollution but to control pollution. So I'm sorry, because we cannot stop pollution to the whole extent. To a particular extent, a limit should be prescribed.
But we can introduce some sort of treatment plants, etc.
But still, it will not be completely pollution free. To a particular extent, we should actually encourage pollution, because it, in fact, you were referring to the term economic crisis in 1970s. So development includes exclusion of economic crisis.
So I strongly believe that we cannot completely exclude pollution. And there is a wonderful process which has been followed in Japan. That is the share market of Japan, the company, the, the non-polluting companies are given a green tag in the share market. The less polluting companies is given a red tag,
Tax subsidies.
and the
Even tax
highly
subsidies
polluting
also.
companies are given a black tag. So these tags actually determine a lot of their share values. So the companies take it as the greatest incentive to reduce maximum pollution. So that could be a better incentive which could be followed around the world.
Even
Yeah, I,
one
I
time it
agree to your
has
tax
also been suggested in a
exemption.
research paper. I had attended last time International Environmental Laws Conference at Indian Society of International Law. I agree
Right.
with you that even the process to give some incentives
Tax
to the
incentives.
pollution-free
Correct,
industries,
correct.
and even when they have to establish the treatment plant, they should be given subsidized loans. This
Correct.
is already there, and we have suggested number of times
Right,
that
right.
this can be done.
But
At the
I'll tell
in the
you,
name
for
of
the
sustainable
multinationals,
development.
exemption of tax is not a burden. Paying tax for the multinational corporations is not at all a burden. Today, Ambani has become number one because of the share values, nothing else. Okay,
That is
he was
also
ranked number one above Bill Gates only because of the share values. That's only because of the economic boom happening in the share market of India. So, which is actually dependent on another number of other structures, depending on import duties, export ratios of NASDAQ, etc. So, if we actually provide certain incentives in order to to increase their capital, be it share capital, so I believe that's the best functioning to reduce pollution. And one thing is very clear: we cannot
it
curtail
cannot be,
pollution to 100%, because development means pollution.
and that is our everlasting concern of the human beings.
Right.
I agree. No problem.
Yes, please.
I think it's not working. I mean, little late because of that session. I don't know what happened before, but the concluding remarks, as we're talking about the punishment itself, in the Environment Protection Act and other pollution control acts in India, which have some certain provisions which requires that if any offence regarding the pollution or environmental pollution is committed, if the court cannot take cognizance of that case unless and until 2 months notice shall be given. This is an obstacle which is created only in these environmental acts. At one hand, the Supreme Court has said that environmental pollution itself is a violation of human rights, is a violation of right to life, equality, and all the constitutional provisions. And the remedy is provided under Article 32 in the form of PIL. But at the same time, regarding, as he's stressing about the punishments, but the law has been made so liberally, which favors the industries particularly. What I feel that it is totally favored by the political parties to the
Yeah.
to the industrialist by making such a provision, which creates an obstacle in punishment, because you cannot file a complaint. And if you file a complaint, court will not take cognizance unless and until 2 months notice is given. And this 2 months notice, which is a period in between the industrialists can manage everything. And I don't find any cases wherein the industrialists have been punished. This is a very much clear policy of the state itself.
But usually,
Where is the
what I
political
have
will?
seen in my practical life, earlier there was another government in Punjab, and now the government has got changed. And during the regime of that earlier government, former government, the Punjab Pollution Control Board was allowed to issue this notice and closure notice under Section 33A,
Yeah.
and the industries was used to be closed. But now the government has changed, and they have shake their hands with the industrialists. So now it is all the
See,
game which is being played by the politicians. Now they have shake their hands with the politicians,
unless and
and
until law is changed, you are not
they
able
have
to
No,
do anything.
revoked their powers from Punjab Pollution Control Board, and now the Pollution Control Board is not feeling itself as competent as it was earlier.
no, I'm
In
sorry.
fact,
fact,
that
Can
is
I?
there is one.
Excuse me. I believe I'm sorry. I extremely disagree with your point, because every person has got a right to explain himself before being judged as a culprit or guilty. So the same chance is given. It's a guarantee.